statutory obligation.
Just on the chronology, could we just clarify, what date did you first become aware that a mistake had been made?
The 7th of December.
The 7th of December. So when Mr. Hartnett, 2 days after shaking hands or not shaking hands with Goldman's, or 3 days rather, it was the weekend, he had his meeting on the Friday and spotted, he said, the mistake on the Monday. He didn't get in touch with you at that point?
I believe he got in touch with me as soon as he was able to.
The 7th of December? I don't think anything
turns on that.
So
but I think...
No, because I think the chronology is quite interesting, because I've always found it odd that the mistake, whether the mistake was spotted before or after the meeting on the 30th of November. So could we just go through the chronology? The meeting was held on, I think, the 19th of November. Well, why don't you take us through the chronology? So the meeting with Goldman Sachs and Mr. Hartnett was on what date?
I believe it was the 19th of November.
19th of November, when the deal was done. And yet you didn't learn of the mistake until the 7th of December. And yet you're the chief lawyer advising on whether this is a binding or non-binding deal. Okay. Could you just talk us through what happened between the 19th of November? Who first brought it to your attention? When did you first learn of a mistake having been made?
The 7th of December.
Okay, and who brought that to you? Was that Mr. Hartnett or one of your lawyers?
No, Mr. Hartnett.
Mr. Hartnett. He didn't tell you which case it was. He just said one of the cases.
He might have done, but we have... I'm not trying to be funny, but we've got 8,000 cases.
No, I appreciate that.
If I don't need to know...
Could you clarify, ahead of today's hearing, did you read the minutes of the 30th November meeting?
Which meeting was that?
That was the high-risk group meeting, which I think was held on the...
Yes, I think I've read that. I don't have them in front of me, but I think...
I presume there is a detailed minute of that meeting, is there?
I can't recall now. I don't have it in front of me.
Okay. Well, it's difficult to read it if it doesn't exist, but one would assume a meeting of that gravity would have a minute taken. I mean, do those meetings usually have minutes taken?
Yes.
Yes. But you haven't read it prior to coming today?
I have read it, but I don't have it in front of me now.
Right. Okay. So it does exist. Were any of your team at that meeting?
Yes.
Okay. And did any discussion take place around the Goldman Sachs deal at that meeting?
Yes.
So was the mistake spotted or discussed at that meeting on the 30th of November?
I believe so.
Okay, so the meeting on the 30th of November, the mistake had been identified then, more than a week before Mr. Hartnett telephoned you.
Mr. Hartnett spoke to me on the 7th of December.
Sure, okay. Did no one from your team communicate that a mistake had been made on something of this gravity between the 30th of November and the 7th of December?
Did anybody from my team tell me?
Yes.
No.
So your team, your lawyers, went to a meeting where they established that a serious mistake had been made, but they didn't tell you as General Counsel?
My lawyers are appropriately senior and they can engage on this sort of thing if necessary. They don't need to tell me everything.
Sure, I appreciate lawyers are involved. I would assume lawyers drew up the contract. So it's a statement of the obvious to an extent that lawyers were involved. What I'm saying is you alluded to in terms of your answer to the Goldman's meeting on the fact that you have very senior lawyers who you give discretion to as a result of their expertise. And are you a tax expert yourself?
I'm not what you call a tax lawyer.
No, right. And the three lawyers you've hired, the three people beneath you, are they tax experts?
The three directors that I have who have come to work for HMRC under fair and proper procedures rather than people that I've hired, are not what you'd call tax lawyers.
Experts. Okay, so you're not. I'm sure it was a fair and proper. I wasn't suggesting it was a fair and proper. What I'm just establishing, we discovered at the last hearing that there's only one tax commission who actually has detailed knowledge of tax, and what you're saying is General Counsel and the 3 senior lawyers hired, none of which are tax experts. So coming back to the Vodafone settlement at 1.25 billion, it may be perfectly logical, therefore, if you're not a tax expert, for you to give senior lawyers within your area a degree of discretion. What I'm trying to establish is whether they advised, with their expertise, that the 1.25 billion pounds was the correct amount.
And my answer to that is, as before, that I can confirm that lawyers were involved throughout, but I cannot go into any more.
So you can't confirm
detail.
whether they gave. Okay, could I put it, because I think the quantum is much more important than with Goldman Sachs, because between 2001 and 2011, as far as Vodafone are concerned, we're looking at in the region of £25 billion of profit. And so the actual settlement appears, the 30%, obviously it came down in the latter years, but the settlement seems to be strange on a number of levels. First of all, it seems to include the 2011 and 2012 profit. But given that the settlement was reached in 2010, I'd just welcome your thoughts on how they knew what the profit was going to be for 2011 and 2012, given that those profit hadn't been realised. But also, the 1.25 billion looks like it's been based on around 20% of Vodafone's profits, which means the Exchequer may have lost around £8 billion of tax, which makes the Goldmans look quite paltry in comparison. So the reason I'm saying is we're talking potentially, we can't get the figures because Mr. Hartnett won't answer the questions, but we're looking at potentially £8 billion of tax lost. We're looking at a company that was given 5 years to pay, even though it was sitting on a cash pile. And we're looking at a settlement based on future profits which were unknown, even though the department doesn't allow such considerations to be given, and the legislation hadn't been passed by Parliament, so undertakings couldn't have been given by the department. And what I'm trying to establish, Mr. Inglese, is that whilst you might not be a tax expert and your deputies may not be a tax expert, who from your lawyers was advising Mr. Hartnett to ensure that we can satisfy ourselves that that sum for £1.25 billion was correct?
I'm afraid I can't comment on that.
Why not?
Because that is covered by legal privilege, and I can't comment. I would like to say something about the fact that you keep on mentioning tax expertise. Can I do my job without being a tax lawyer? Of course I can.
But we don't know what involvement they have. That's the issue. We don't even know if interest was charged on this 1.25 billion. One assumes it wasn't, because Vodafone released, I think, 900 million that they had set aside. They stopped setting money provisions aside in 2006, incidentally, probably assuming they were going to win the case, and then found that they didn't, and would have had to set aside far more had they known they were going to lose the case. But this 1.25 billion, we don't even know what interest that included. Are you able to tell us what interest that included?
I can't comment on any of that.
But who were the experts from your department that were providing the tax legal advice to Mr. Hartnett?
All I can say is lawyers involved throughout, and that's all I can say.
In terms of Vodafone, could you just clarify with the settlement, was any discretion exercised over the 1.25 billion, or was that the correct amount in law?
Yeah, I'm afraid I cannot go into that. I can't comment on that.
Well, I'm just asking from a legal process point of view whether any discretion was exercised or not.
I can say at a general level, when a settlement is reached, it's reached by agreement.
But Mr. Hartnett said no discretion was exercised. He did not take a penny less than the correct amount in tax. Just as a matter of law, I just wanted your confirmation that is correct, is it?
That's my understanding that it's correct.
So no discretion over interest was exercised?
My understanding from speaking to all my colleagues is that the Vodafone settlement was correct.